Jai Hind viewers, and a very warm welcome from Team The Indian Lawyer to this episode of the Indian Lawyer Legal Tips. Today's topic is contemporary, based on Operation Sindur, the India-Pakistan conflict, and this episode will deal with legal aspects of war. I am Sushila Varma, Advocate and Chief Consultant, bringing to you this episode. Let us begin by understanding what is the India-Pakistan crisis and when did it begin. It began in 1947 with the partition of Kashmir, then followed by the First Indo-Pak War in 1965, the Second Indo-Pak War in 1971, and then finally the Kargil War in 1999. The relationship between India and Pakistan has been intermittently spotted with very high tension incidents since 1947. On 22nd April 2025, militants who claimed that they were from Lashkar-e-Taiba attacked a tourist convoy in Pahalgam, Kashmir, killing 26 people. The reason they were killed is because they could not recite the Kalma. This is probably one of the most shameful acts in which the religious diversity between the Hindus and Muslims can be seen. This was the deadliest terror strike in India since 2008, condemned by the Indian government, the people of India, and of course the global world.
India will identify, track and punish every terrorist and their backers.
On 7th May 2025, India retaliated by launching Operation Sindur, a series of 24 precision missile strikes at 9 locations in Pakistan and POK, where the India's actions were controlled, precise, measured and non-escalatory, targeting only 9 terrorist camps that were razed to the ground. Now let us examine what is the international law regarding wars. The foundation principle of the laws of war are what is mentioned in the Charter of the United Nations. Article 2.4 of this Charter prohibits the use of force by any member state. Article 2.4, for the convenience of the viewers, has been reproduced on the screen below. This principle is widely recognized as peremptory norm of international law and means that there should be no use of force unless and until it is a means of self-defense. Now let us examine what are the key principles underlying the laws of war. The global rules governing the conduct of armed conflict is codified in what is known as international humanitarian law, also known as laws of war. These laws established fundamental principles that must be adhered to by all parties in an armed conflict, seeking to minimize human suffering and protect those who are not taking part in the hostilities. The principle of distinction mandates that parties to a conflict must at all times differentiate between the military and the civilians, and as such they should not attack civilian objects or civilians per se, and only restrict the use of force to their counterparts, that is the military combatants. The principle of proportionality prohibits attacks that are expected to cause incidental loss of civilian life, injury to civilians, damage to civilian objects. Then there is a principle of necessity which prohibits the infliction of unnecessary suffering on the combatants and the civilians. The Geneva Convention, along with their additional protocols, form the core of the modern IHL. These international treaties have been widely ratified and set out the detailed rules that all countries must follow and concerns different aspects such as treatment of the wounded, sick combatants, prisoners of war and civilians during armed conflict. The principles of IHL are interconnected and strive to maintain a balance between military necessity and humanitarian protection. Now let's examine another aspect. The UN Charter function, whether or not it is a binding law or is it just a guiding mandate. I would say that the United Nations Charter is generally considered the law. The only problem is that the Charter is binding on only those states which are part or which are signatories of the conventions. In the event that you have not signed any of the conventions, it is not necessary that you will be bound by it. It is completely a matter of choice. Now let us examine what the international law says about aggression and what criteria must be met. The United Nations General Assembly passed Resolution 3314, which defined aggression. As per Article 1, the use of armed forces by a state against the sovereignty, territorial integrity or political independence of another state or in any other manner inconsistent with the chapter of the United Nations as set out in this definition would be deemed to be an act of aggression. Now let us see what are the specific acts that qualify as aggression. These would be the invasion or attack by the armed forces of a state of the territory of another state, bombardment by the armed forces of a state against the territory of another state, the blockade of ports or coastal areas of one state by another state, an attack by the armed forces of state either on land, sea or air force or marine of another state. Article 2 clarifies that the first use of armed force by a state in contravention of the Charter shall constitute prima facie evidence of an act of aggression. Now, Article 5 underscores the fundamental illegality of aggression, stating that no consideration of whatever nature can serve as a justification for aggression and that a war of aggression is a crime against international peace. Now let us see how the international law will perceive India's countermeasure under the existing international laws of war. The right to self-defense under the United Nations Charter is a fundamental right. As per Article 15 of the Charter of the United Nations, it provides the primary basis for a state to use force in self-defense. Now, Article 53 of the UN Charter states that nothing in the present Charter shall impair the inherent right of an individual or collective self-defense if an armed attack occurs against a member of the United Nations until the Security Council has taken measures necessary to maintain international peace. This article is widely understood to codify a pre-existing inherent right to self-defense. A crucial trigger for the lawful exercise of this right under Article 51 is the occurrence of an armed attack against a member state. Now, let us see what are the Indian statutes or regulations that governs the country's conduct in times of armed conflict. As far as India is concerned, it is obviously the Constitution of India. Article 355 of the Constitution imposes a duty on the Union to protect the states from any external aggression or internal disturbance. India's military doctrine has evolved over a period of time, and in this also we notice that there is a move from doctrine of deterrence by denial to deterrence by punishment, which is exactly what happened in Operation Sindur. In the context of the Pahalgam terror attack, India's response, the government's actions are framed within the context of self-defense against cross-border terrorism. Now let us understand the difference between treaties and conventions. I would say that the word treaty and convention is often used interchangeably to refer to a binding agreement between states. However, treaty is generally considered as an agreement between two or more parties, whereas an international organization, states and individuals can collectively sign a convention, which is a multilateral treaty that aims to address global issues and establish international norms. Now, one thing that may be of interest to our to our viewers is that India and Pakistan have entered into various bilateral agreements over the years, such as the Indus Water Treaty. Now, let us address one very important question, which is Pakistan's action deemed to be a United Nations prohibited aggression? What legal repercussions could Pakistan face? Now, the first would obviously mean that India could take action under the provisions of self-defense and attack Pakistan, which is what we have already done. Over and above that, sanctions or reparations can be demanded by India. Sanctions can be various types. Reparation would mean that the action of making amends for the wrong done has to be made by Pakistan in order to help India to recover its losses. Now, who will try Pakistan in this particular acts of aggression? Well, there are two international bodies. One is the International Criminal Court and the other is the International Court of Justice. Now, what happens is the International Criminal Court only deals with individuals who have been guilty of war crimes, whereas International Court of Justice deals with matters which pertain to states and decides disputes between states or inter-countries. Now let me get into the Indus Water Treaty and how it will impact Pakistan. The Indus Water Treaty is a long-standing agreement between India and Pakistan which was brokered by the World Bank in 1960 and governs the sharing of waters from the Indus River system. Following the Pahalgam attack, India unilaterally suspended its participation in the treaty, putting the treaty in abeyance. Now, what would this necessarily mean? It would mean that Pakistan would not have water for its irrigation. However, India would have enough water for hydropower generation. It could also ensure that it takes adequate measures for flood control, water storage, etc. Another thing that has come up time and again in news briefings is contactless wars. Let me explain what contactless wars mean. Contactless war refers to a form of warfare where states utilize all elements of their national power, including non-military and military, non-kinetic and kinetic means, and exertion of influence over an adversary, targeting its population, sovereignty, government structures and economy without direct physical engagement of their own forces. This includes information operations, cyber warfare, and attacks using autonomous weapon system. Now, coming to the International Court of Justice. What exactly is the International Court of Justice and how can anybody be accountable for alleged war crimes? At the international level, the primary judicial authorities which have jurisdiction over matters relating to war crimes is the International Criminal Courts, but like I mentioned earlier, these would only be to individuals. Hence, it would be for war crimes such as genocide or acts against humanity. This would find reference in the Nuremberg and Tokyo tribunals, which tried Axis leaders who had committed crimes against humans. The International Court of Justice, however, has much larger powers and it has the jurisdiction to prosecute individuals accused of war crimes, genocide, humanitarian crimes of aggression. Over and above that, the ICJ also has the power as the judicial organ to settle disputes between states based on international law. Now coming to an extremely important aspect of warfare, that is nuclear war. Now, given that both India and Pakistan are nuclear armed states, any escalation or conflict would raise very serious concerns under international law. The International Court of Justice, in its 1996 advisory opinion on legality of the threat or use of nuclear weapons, provided the current most authoritative legal analysis on the issue. It deals with the court has dealt with the fact that there is no comprehensive and universal prohibition on the threat or use of nuclear weapons in either customary or treaty law. It has stated that the threat or use of nuclear weapons contrary to Article 2.4 of the UN Charter and not meeting with the requirements of Article 15 would be unlawful. Furthermore, the ICJ has found that the threat or use of nuclear weapons would generally be contrary to the principles of international humanitarian law due to their vast and indiscriminate effect of causing widespread, long-term and very severe damage. Now let us examine what are the guiding principles of India's own nuclear policy. India's nuclear policy is centered around the principles of no first use and credible minimum deterrence. NFU principle implies that India will not initiate a nuclear attack but will only retaliate in response to a nuclear attack on Indian territory or forces. Credible minimum deterrence means maintaining a nuclear arsenal sufficient to deter any adversary from launching a nuclear first strike. India also retains the option of nuclear retaliation against a major attack by using biological or chemical weapons. Sadly, Pakistan's nuclear policy does not include a no first use commitment. They claim that they have a right to have nuclear weapons because they have a giant by the name of India as their neighbor, and this neighbor has a huge force which Pakistan cannot match up to. Now, let us see how India can justify its current stance. Like I mentioned earlier, India has the right to self-defense under Article 51 of the United Nations Charter. India has also emphasized that its actions are targeted only against terrorist infrastructure and they do not want to harm common people of Pakistan. India has played by the rules and has ensured that they have not caused attack toward the civilian population but only to the military bases, including the Air Force, etc. Now let us see what is the role that the Supreme Court of India can play in a war-like situation. I would say that the Apex Court possesses the power only of judicial review over executive actions, and it also has the power to ensure that the rights of its citizens are not taken away. But over and above that, it is very unlikely that the Supreme Court of India will exercise any power in a war situation. Now let us examine what are the special powers given to the Union government if the Parliament declares war. Once the Parliament declares war, emergency provisions under Part 18 of the Constitution will be invoked. Under Article 352, the President can declare a national emergency based on war. The national emergency, the executive power of the Union will extend to giving directions to states. Parliament gains the power to legislate on any matter including those enumerated in the state list. Article 358 provides for automatic suspension of fundamental rights under Article 19, that is freedom of speech, assembly, etc., if there is an emergency situation like a war. And the President can also issue orders suspending the right to move any court while the country is at war. Furthermore, Article 354 allows the President to modify the provisions relating to the distribution of revenue between the Union and the states. One last thing that I felt I should bring up is what is the legal implication of crossing the line of control and how is the LOC defined in international law. The LOC is a de facto military border between the Indian administered and Pakistani administered parts of Kashmir. It was established in 1971 and formalized in 1972 under the Shimla Agreement. It serves as a de facto border but is not recognized as an international border. Crossing the LOC by military forces of either India or Pakistan generally constitutes a violation of the Shimla Agreement. Such action would be considered a breach of international law, potentially qualifying as an act of aggression unless justified as self-defense. Finally, we should look at Pakistan's sheltering of terrorists. Now, what does India do? The problem with the Indo-Pakistan relationship and the sheltering of terrorists is that there is no extradition treaty or a bilateral or multilateral agreement between India and Pakistan that outlines the conditions and procedure under which one state will surrender an individual accused or convicted of a crime in another state. The purpose of such treaties is to facilitate international cooperation in law enforcement and prevent criminals from evading justice by fleeing to another country. Sadly, because of the lack of a bilateral extradition treaty, Pakistan refuses to hand over the terrorists to India. India requested Pakistan to extradite Hafiz Saeed, who was the mastermind in the 2008 Mumbai terror attack, but till date this has not been done. Apart from this, there are other terrorists who have also been on the list for which India has sought extradition, but sadly they have not come to India. In conclusion, I would like to wrap up by saying, dear viewers, this is a very testing time for India, and we as a country and country citizens should unite and bond as one India and not let differences of caste, creed, religion, or political indifference affect or divide us. This is a time for the new India, which has to be united in adversity and has to appear very strong to the global world. Thank you, dear viewers, for consistently watching us. If you have found this video useful, please like, share and subscribe. I feel that if we share this video with as many people as we can, many people will be aware of where India stands when it comes to its defense. Thank you. Jai Hind.